All right, let's go on to record in the Winslow case. The record reflects the presence of all jurors, all counsel. The defendant are present. Good morning, everybody. Thank you for being on time. As I mentioned yesterday, today we will hear the closing arguments. We're going to begin first with Mr. Owens. Are you ready, Mr. Owens? All right, go ahead.
Kellen Winslow took from these women what he wanted. Kellen Winslow took from these women again and again and again. At the outset of this case, I told you what the evidence would be. Now you've heard it. Now you know. Now you know as you sit here with a big decision to make what he's done. And make no mistake, ladies and gentlemen, these women had something taken from them against their will, by force, because they were afraid. Because they were afraid of what he was going to do to them if they didn't submit to what he wanted. Make no mistake, ladies and gentlemen, this man took what he wanted from them and threw them aside like a piece of trash, because that's what he thought that they were. Make no mistake, he has proven himself to be a sexual predator. Time and time again, motivated by his own perverse sexual pleasure to dominate and take what is not his. Ladies and gentlemen, that is his motivation. To steal their dignity, who they are, regardless of what effect that may have on them. That's what happened here. And you've heard it from the witness stand time and time again. And you've felt it in their words. Jane Doe number 2, soft-spoken, timid, shuddering, afraid of being in the same room as her rapist, afraid to even look at him. Is that all an act? Is that a lie? Well, certainly not. Make no mistake, ladies and gentlemen, she had something taken from her by this man in court, and do not allow his status or his name to take away from that. Make no mistake, Jane Doe number 2 had something taken from her that cannot be given back, that cannot be made whole. And you saw that on display before you. Compelling, consistent testimony from a woman who's been left on the side of a road like the piece of trash that he thought that she was. Jane Doe number 4, a woman with a secret for many years, a secret that she didn't tell to anyone except her best friend, her boyfriend, while waking up, screaming due to nightmares, and the man who would become her husband and the father of her children. Was she lying to you as she sat there, feeling the pain and trauma that she experienced as a 17-year-old girl? Was she lying to you when she sat there and had to recount every possibly minute detail that she was asked about from now 16 years ago in a difficult, traumatic, devastating event in her life? Make no mistake, ladies and gentlemen, she too had something taken from her. And she had the bravery and the courage to come forward. Not for any self-interest, not because she was going to get something out of this, most certainly not. She had to go through hell being here. But because she wanted the truth to come out. She wanted the truth to come out because this impacted her so deeply that she wanted her own daughters to know that they can stand up to a name, a man with status, a man who was strong and rich and successful and had repeatedly taken things that weren't his. Jane Doe number one, a woman with problems, a woman who walks the streets of Encinitas regularly, a woman who's battled alcoholism her adult life. Sure, she comes in here and she talks to you about what happened, and I see your eyes. Everyone sees it. Sounds bizarre. Sounds like it couldn't have happened. But you know what? You know what's bizarre? You know what seems like it couldn't have happened? This defendant's conduct throughout each one of the incidents in this case. This defendant is so callous, so brazen, that after he has been brought to court, charged with crimes involving sexual violence and sexual deviancy, he still acts out against a 77-year-old woman. He victimizes a 77-year-old woman who's doing nothing but her regular routine. He strokes his penis, he gains an erection, and he stands in front of her, feet away, and asks her, "Do you see that? Do you like that?" Ladies and gentlemen, this is sick. It is depraved, it's callous, and it's this defendant in court. Jane Doe number three, a woman who lives down the street, who again has no interest, no motive to lie. She's a woman who's just tending to her garden with her elderly husband inside. And again, so brazen, so callous, so depraved, this defendant goes there time and time again, as you saw from her testimony and the GPS data. And he seeks her out, he targets her, and he exposes himself to her. Had she not run, had she not screamed, had she not called out that her husband was there, what was going to happen to her? This defendant is motivated by pure, unadulterated depravity for his own sexual purposes. And that's what this case has shown. That's what this case has proven. He has proven himself to be a sexual predator, and this case has been proven beyond a reasonable doubt. On June 7th of 2018, Mr. Winslow was contacted by law enforcement. You heard testimony that they received a buccal swab, a DNA sample directly from his mouth. And that's what led to this. Mr. Winslow was photographed that day, and this, as you can see, just based on the description of each one of the witnesses, this is what he looked like while out in the community. We turn to your decision. What is your job as a juror? It seems pretty simple. It's two things. Your duty as a juror is to decide the facts that have been proven and to follow the law. Once you decide the facts, using your common sense, your good judgment as members of the community, your life experience in knowing that lightning certainly doesn't strike twice, let alone 5 times, and you join together in one voice after reviewing all of the facts, after following the law that's been provided to you by the court, and you have one job to do. You have a privilege and you have a responsibility as members of the community to find this defendant guilty, because that's what's been proven to you. It's a weighty burden, I understand, but it's one that each one of you swore to uphold, and I'm certain that you'll do it. What are the facts of this case? How do you decide the facts? The law gives you the tools that you need in order to render a true and just verdict, finding him guilty. You have 5 victims who separately reported their crimes. Unknown to each other, as I told you before, unknown to one another and barely known to Mr. Winslow. Jane Doe number 1 might walk the streets in that area regularly, as she testified to and her daughter testified to. She might pass by Lake Drive. She has no idea who this guy is, as she said. He gave her a false name, Dominique or Deshaun or Michael, something to that effect. She thought maybe he was a black gangster from Oceanside, for all she knew. She had no idea that he was some professional football player who lived in Encinitas. 5 victims testified to what the defendant did. Separately, never spoken to one another, and yet there are commonalities in what the defendant did to each of them. 5 victims corroborate each other. It shows, according to the law, that this defendant had this sexual predisposition to commit crime. Ladies and gentlemen, the fact that there's not 1 and not 2, but 3 rape victims, the fact that the defendant committed crimes against Jane Doe 3 and Jane Doe 5, all of that information is cross-admissible for you to consider the truth of all of the charges here. All the facts are intertwined. And that's why you, sitting as a jury, get to hear all of that information so that you can look at everything and decide what's been proven. There has been no evidence of consent by any one of these victims. I'm going to talk to you about the elements of each crime and where consent comes into play. It comes into play in the forcible sex crimes and kidnapping. That's it. Consent is not an element of rape of an unconscious person or indecent exposure or lewd acts or elder abuse or elder battery, okay? We're going to talk about consent because that's all they've got. That's what they're going to argue to you. You've heard no evidence whatsoever to suggest that any one of these women consented to what Mr. Winslow did to her. And that's what they're going to try to get you to buy. Make no mistake, high-priced lawyers, successful attorneys, experienced advocates will do what they can to try to persuade you to their position. But ladies and gentlemen, there is no evidence to support them. No motive to lie by any victim. I said Jane Doe 4 went through hell coming here and having to testify and relive what happened to her. Am I wrong about that? Did Jane Doe 2, as she sat there trembling in that witness stand, did she look to you like she was somehow going to get something out of this? No. All of these women have had their lives disrupted, put under a microscope, not just in front of you, but in front of all this. Their faces may not be shown, but their voices are heard. You think they wanted that? You think they sought that out? You think Jane Doe 1 was banging down the door of the sheriff's department or the DA's office when we were bringing her in months later to talk to her about what had happened to her? You think she was thrilled to learn about what was going to happen over the court's process? Jane Doe 2, that woman, meek, quiet, not very many friends. Not a husband to lean on like Jane Doe 5. Not a support structure like Jane Doe 4 and a family. All alone in this world. She gets brought in here because of what he did to her. And what is all of the evidence shown? That Mr. Winslow is predisposed. He has an inclination to commit sex crimes. The law recognizes that there are individuals among us, people within the community that are wired differently, that do take what's not theirs. And we're not talking about a car stereo. We're talking about one of the most vile, despicable crimes we have. That's what this defendant has done. What else did you hear? You heard about the law enforcement investigation. And as you can see, this came in as a stranger rape initially with Jane Doe 1. No suspects identified, a dark black Jeep with a hard top, Dominique or Deshaun, perhaps, tattoos on his arms, muscular build, being picked up on one part of Encinitas, driven to the back of a store shopping center, raped under threat, directed to go different locations, seemed far-fetched to the detectives, certainly, but they still did their due diligence and tried to follow up on it. And what did we learn during the course of that investigation? The defendant's DNA ends up being inside this victim's pants. So we have him identified. And then the question for you is, well, was this woman making it all up? She's lying about the threats. Was the defendant really not going to kill her if she didn't do what he wanted? And then you have an entirely separate report by a woman who's never met Jane Doe 1 when Jane Doe 2 comes forward. About 2 months later, the day after it happened, through the encouragement of a friend of hers, because she certainly didn't want to talk, she was going to stay silent, most likely. And we all understand why. In remarkably similar circumstances. Jane Doe 2 comes forward, and the law enforcement investigation flows from there. She completes a sexual assault examination. She's consistent when she talks to Deputy Chad Latonio, Detective Adrian Moses, Nurse Williams, Detective Johnson. Her testimony, both in the preliminary hearing, as you heard so much about, as well as before all of you. What does she tell you happened? This man took from her when all she wanted to do was get coffee, when she initially felt safe with him. And then she was brutally raped. Somewhere along Manchester, on that dirt stretch, where there's no lights for anyone else to see, to come to her aid. And then we have Jane Doe 3, who again, willing to report, but reluctant to have to actually participate in the process. And then we have Jane Doe 4, willing to report in order to support the other women. And then Jane Doe 5, who unmistakably, unquestionably knows what happened with her and the defendant. You heard from the fresh complaint witnesses, or what's also called outcry witnesses. You heard from the spouses. You heard from gym employees. You heard from the deputies. You heard from the detectives. You heard from Nicole Edwards, Brandon Guillermo, Troy M. This is the anatomy of a sex crimes case. That's how these cases are proven. You have the victim's testimony that's then confirmed and corroborated by the prior statements that they've made, the physical evidence that gets collected, and circumstantially supporting and corroborating what they've told you. You heard from crime scene specialists who executed the search warrants and forensically processed Mr. Winslow's vehicle. You heard from the forensic nurse, Ms. Williams. You saw the actual shots from the surveillance pole camera that was put into place pursuant to a court order outside this defendant's house, right after he had had that buccal swab taken from him on June 7th. You heard from the RCFL forensic examiner who came in and testified to the download of his laptop. You heard from the crime analyst who testified to the download of his phone. You heard all of this evidence because what it does is it supports and confirms and corroborates what you know to be true now, that the defendant has committed each one of these crimes. You also heard about the GPS data. And as Angela Rosa testified, GPS data comes from cell phones, right? It can come from a lot of different devices. You heard a stipulation from the people in the defense that GPS data put him at the same location as Jane Doe number 5 during the time frames that she reported these incidents having happened. You heard, according to that Strava application, undeniably that this defendant committed indecent exposure against Jane Doe 3. He was there. We've proven that. So regardless of whether or not her husband interjects in the body-worn camera and says, "Are you saying 5'9", and then she agrees to that and then agrees to that on the witness stand, it was this defendant. Make no mistake. 5 victims, 5 separate women. Jane Doe's 1, 2, and 4 are victims of rape at the hands of Mr. Winslow. Jane Doe's 3 and 5 indecent exposure, and lewd act in public, as well as elder abuse and elder battery. Those are the charges. Jane Doe 1, broken down, 3 counts. Kidnapped for rape, rape by force or fear, oral copulation by force or fear. Jane Doe 2, rape by force or fear, and sodomy by force or fear. Jane Doe 3, indecent exposure. Jane Doe 4, rape by force or fear, and rape of an unconscious person. I'm going to talk to you about the elements and the difference between the two. But the court's already provided you with the instructions, which allows you to have the tools to view the evidence so that when you hear the arguments, you can decide what makes sense, what's logical, what is the one and only reasonable conclusion from all of the evidence. And Jane Doe 5, as I said. 2 separate incidents. 1, lewd act in public, early in February of 2019. A separate lewd act in public, along with the elder abuse and battery charges from February 22nd of 2019. So I'm going to tell you now, uphold your duty and follow the law. We're going to start with a very basic premise. And there's going to be times where when I discuss the law with you, I'm going to discuss its application of the facts, but it might seem like it gets a little boring sometimes. What I'd like you to do is look at it as building blocks, because the law does give you the tools you need to render a true and just verdict. Most basic premise under Cal Crim 1190. Conviction of a sexual assault crime may be based on the testimony of a complaining witness alone. That's not all you have here. You've got certainly much more. But that is a fundamental tenet of criminal law. Crimes often happen. Crimes of a sexual nature often happen with no one else around to see them. And if credible, if believed by you, based upon the testimony of the witness, that in and of itself is enough to be proof beyond a reasonable doubt and lead to a conviction. But that's not all you have to rely on, because you're, I'm sure, wondering, how do we use all of this information we've been given? How do we use all of these other crimes? Are we allowed to? And you've been instructed that you most certainly are. So how do you use the other crimes? Under Cal Crim 1191, as the judge read you yesterday, if the people have proved that the defendant committed one or more of the crimes against either Jane Doe 1 or 2 or 3 or 4, if we have proven that they committed either one of them or more of them, then you may conclude that Mr. Winslow was disposed or inclined to commit sexual offenses, that he had that predisposition. It's what the law tells you. And not only that he had the predisposition, but you may also conclude that he was likely to commit, and he did in fact commit, the other sex offenses charged in this case. If you set aside Jane Doe 1 entirely and only focus on what Jane Doe 2 told you, and you believe that she is credible and consistent, and you felt that emotion, that pain, that trauma that she felt when she testified, and that's now been proven to you, you can then use the fact that Mr. Winslow committed the rape and sodomy by force or fear of Jane Doe 2 to then help you prove beyond a reasonable doubt and decide that he committed the rape and oral copulation and kidnapping of Jane Doe 1. Because of course, logically, reasonably, when you hear such similar crimes being committed against more than one woman, mere months apart, under very similar circumstances, of course, you can use them and compare them and decide, based upon the totality of the evidence, that both crimes were committed and that this defendant had that disposition to commit them. But that's not all you have. It's not just Jane Doe 1 and 2. You also have the evidence presented to you from Jane Doe 4, who says that while perhaps under different circumstances, they were much younger, they were at a house party, much different circumstances, it still shows this defendant's predisposition to commit forcible rape. Because that's what he did with Jane Doe 4 when she protested, crying out, "No, no, no, stop, stop," as he continued to thrust himself inside of her. And even after she pushed against his hips, he turned her around, flipped her onto her back, and continued to rape her. How similar is that to what he did to Jane Doe 2? As he raped her from behind as she stood halfway in and halfway out of that vehicle. And then as she screamed from the pain of him sodomizing her, he grabs her by the throat, suffocates her, chokes her, and turns her around, facing her, saying, "If you scream, I'll kill you." And then he continues to forcibly rape her. Consider those facts. And the law tells you to consider those facts and those similarities in finding beyond a reasonable doubt that he committed all of these crimes. Independent evidence. You're going to hear a lot about that, certainly from the defense. Independent evidence, as the law tells you, may include evidence of the defendant's sexual misconduct against a separate victim. Right? Again, logically, reasonably, that makes sense, using your common sense and experience as a juror. Such sexual misconduct, according to the law, if believed by you, if he commits one crime and you've found that beyond a reasonable doubt, if that's believed by you, that standing alone may constitute independent evidence that corroborates another victim's allegation. Doesn't that make sense? And that's going to be within a special instruction, and I'm going to talk to you in more detail about how that applies in this case. But that's the state of the law, and that's what you can do in guiding your deliberations. So we're going to talk about each one of the crimes. There's 12. I keep telling you about the 5 victims. You know what the charges are by now. You could probably write a treatise on rape law at this point. Rape by force or fear, Jane Doe's 1, 2, and 4. We're going to start with Jane Doe 2. First, there are elements for each one of the offenses, and the court provided you with this law, but it takes time to digest and understand. First, defendant had sexual intercourse with the victim. Defendant and the victim were not married to each other at the time of the intercourse. It seems like an archaic notion of the law, but it still exists, at least when we're not dealing with the context of spousal rape. Third, the victim did not consent to the intercourse. And fourth, the defendant accomplished the intercourse by force, violence, duress, menace, or fear of immediate and unlawful bodily injury to the victim. The first and second elements are not going to be at issue. They're not going to be disputed, right? You've heard that they called this buyer's remorse, essentially. No strings attached sex, and they're just making this up when they reported it to law enforcement, okay? That's the defense. But is there any evidence that any one of these victims consented? Most certainly not. And how was it that he accomplished the sexual intercourse? Was he forceful? Did he intimidate them? Did he instill fear in them? Each one of these victims, Jane Doe's 1, 2, and 4, testified in a way that provides direct evidence that that element is met. We have the elements that exist, and then also the definitions that correspond to the elements. Again, not likely to be disputed, but sexual intercourse, the act itself, simply means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required, and that's included within the law because with Jane Doe 1, there's no sexual assault examination completed, but she certainly testifies that he penetrated her vaginally. Jane Doe 2, there was a sexual assault examination, and it shows the erythema and the redness that you heard Nurse Williams testify to. But she also gave you direct evidence that he penetrated her vaginally. And Jane Doe 4 testified unequivocally that as she came to, as she regained consciousness, he was already engaged in penetrating her vaginally. And then after she resisted and protested, he turned around and continued to penetrate her vaginally. Sodomy. Essentially the same elements with a different act. Defendant committed an act of sodomy with the victim, and sodomy, similar but different in a way, sodomy is any penetration, no matter how slight, of the anus of one person by the penis of another. So Jane Doe 2, she testifies that he, whether it be by accident or not, that he penetrated her anally and stuck his penis inside of her. And it hurt her so bad that she screamed aloud. That's sufficient penetration. That's sufficient evidence to prove the act. But then we get into the definitions of force or fear. Force simply means that there's force if a person uses enough physical force to overcome the victim's will. So what does that mean? How much is enough? That's in the eye of the beholder, right? Threatening to harm someone, doing so in a forcible way, could be enough for someone to submit. It really depends. Fear. Fear can be instilled and fear can be shown if the victim is actually and reasonably afraid. So when Jane Doe 2 is driven to a remote part of Encinitas without anyone else around, where it's dark, it's isolated, she certainly can't outrun him. Is she afraid? Well, she's provided you direct evidence that she was actually afraid, most certainly. Can't deny that. But was that reasonable under the circumstances? Of course. A woman of her age, with a man of his build, his strength, his power, how was she supposed to get away? Menace. It's a legal term of art, but it simply just means a threat, statement, or act showing an intent to injure someone. If you don't do this, I'm going to kill you. You're going to fuck me, or I'm going to kill you. Duress. Similar to menace, it simply means a direct or implied threat of force, violence, danger, or retribution. If you tell anybody about this, I'll murder you, as he throws her out of his car. And this is an important concept. I bring it up last because it illustrates the way the law defines what a sexual assault victim has or does not have to do. It is not required under the law that the victim physically resist or fight back or run when they're being sexually assaulted. This is the man who is on trial for raping these women. This is the man that the evidence shows violently, menacingly, using threats, raped these women. You cannot victim blame because they didn't try to run into the back of a dry cleaner's. You cannot victim blame because Jane Doe 2 didn't immediately run to the first house that she could find to say what happened. Ladies and gentlemen, the law does not require that a victim fight back, resist, or flee. And of course it shouldn't. In that type of a traumatic scenario, no one knows how they would react. No one knows what they would do. We might like to think that we would. We might try to instill in our children, our daughters, what to do in that scenario. But what is human nature? We hear about fight, flight, what else? Freeze. What do people do when they're in a traumatic event? You can use your common sense in judging the evidence. So Jane Doe 2, I'm just going to do an overview of the evidence. I know you've heard it, and I don't want to belabor the point. But the defendant, after having ingratiated himself, shown himself to be fairly kind as far as she could tell, he was a personable person, checking in on her sporadically over the couple of months she had known him, stopping by on occasion, that he then picks her up at the transit center, drives her to what she's expecting to be just a coffee date. She was going to spend time with a friend. And think about how she presents. Quiet, docile, maybe a little shy. This person's befriending her. She doesn't have many friends. And she accepts a ride to get coffee with him. But then he takes her somewhere where she did not want to go. She did not expect to go, and she tells you that she was getting nervous and scared and afraid. And what does he do? He drives her to an area where it's dark and isolated, makes a U-turn, pulls over to the side of the road, and gets out. And that's when she knows she's in danger. That's when she knows, she believes then, that he was going to kill her. And what happens? She locks the door. He laughs at her as he unlocks the door, opens it, and then grabs her by the waist, by the arms, pulls her halfway out of the car, turns her around, and she freezes. He uses force to gain compliance, just like a violent rapist would do. And you know that as of May 13th of 2018, he was experienced. He knew how to get what he wanted to take. And that's how he was able to gain her compliance. He's strong, he's forceful, he's intimidating. And she didn't resist at that point. She did what he told her to do. He rapes her from behind, and then he places his penis inside her anus. It causes her to scream. He chokes her to stifle her yells for help due to the pain. He turns her around. How hard would it be for this man to grab that woman by the neck and turn her around? He says, "If you scream, I'll kill you." She says, "I won't scream if you don't hurt me." What else is she expected to do in that moment? So he lets go. Time slows down when you're in an event like that. You saw her reliving that moment. She didn't know what to do. She was afraid. She allowed him to do what he ended up doing, not what he wanted. She was scared to death. The defendant laughed at her, said, "We're going to have sex." She pleaded with him, "No, please, please don't do this." He said, "It's a done deal, you have no choice." Grabbed her wrist, raped her. She believed there was no way out. She didn't struggle because she says she was in survival mode. Now, what happened after he raped her and sodomized her on the side of the road? How much time would that take for him to be able to take what he wanted? Minutes? To her, she has no way of knowing. All she knows is that she was alone with him and no one came to help. He ejaculated into the dirt, as far as she knew. She thought he was going to die. He tells her to put her clothes on and they drive off. And before he kicks her out of the car, while driving northbound now to Manchester, that then leads up to El Camino Real, in very close proximity to where he lives, he kicks her out on the side of the road, leaves her there alone, and I submit to you, ladies and gentlemen, he then just goes home to his wife and kids, like he'd done before. She's left on the side of the road on Manchester.
Objection, Your Honor, would you strike that last part of the argument? There's no evidence they can infer from that. It's prejudicial.
No evidence of what?
Going home to a family and kids, there's been nothing presented here in court.
It's a reasonable inference, Your Honor.
Overruled. You can address it in rebuttal. It's proper commentary based on the evidence. You may continue.
You saw a surveillance video from the date of the rape of Jane Doe 1 that shows the defendant leaving in his Hummer, returning in his Hummer, in the exact time frame that Jane Doe 1 says that the rape happened. It's reasonable for you to infer that as he drops Jane Doe 2 off on the side of the road on Manchester, that he continued driving northbound. He makes a left onto Santa Fe, which is right there, and then another left onto Lake Drive, which is where he lives with his wife and his children. Be reasonable, ladies and gentlemen. Draw reasonable inferences from the evidence. Now, what does she do? She walks across the city of Encinitas alone, scared, afraid, trembling, fearing that people are coming to get her because of what he just did to her. She's vulnerable. She's traumatized. And it's not until a friend pulls it out of her, Christina Garvey, that she actually comes forward and reports it. Reluctant, unwilling, ashamed, and hurt. Now, if the defendant fled immediately after committing a crime, the law tells you that you can use that evidence, that conduct by the defendant, to show that he was aware of his guilt. Did Mr. Winslow then just return Jane Doe 2 to where he had picked her up? To then return her to where she regularly slept and hung out in the Encinitas Transit Center? No, he got rid of her. He got her out of the car. He left her somewhere where she would be alone and by herself, not able to find someone to talk to. And he took off. That is evidence of his consciousness of guilt. And that is evidence that you can use to prove beyond a reasonable doubt, or to decide beyond a reasonable doubt, that he committed this crime. Separate and apart from the direct evidence that the victim provided when she testified. It's corroboration. Yeah, and that's called defendant's flight, consciousness of guilt, under Calprin 372. You've heard about the sexual assault examination. Nurse Williams described to you what happens in the course of a sexual assault exam. And you heard, most importantly, that at the time someone has their neck compressed while being strangled, that causes one of the most basic human responses. Being deprived of air causes you to believe you're going to die. It's true of kids swimming for the first time, going underwater. Jane Doe number 2 has her neck compressed by this man. She thought she was going to die. That's forcible rape. That's rape by force or fear. You also heard from Nurse Williams the uncontested testimony. There's no evidence that has been presented to dispute this fact, that in over 50% of strangulation cases, there is no evidence forensically, photographically, to show injury externally. So ladies and gentlemen, the strangulation that she described, the choking that caused her voice to change, that caused her to believe that she was going to die, that caused her to not be able to breathe. The fact that there was no photographic evidence along the neck does not mean it didn't happen. It simply means that it just wasn't there, just like it's not there in over half of the cases of strangulation that Nurse Williams says the literature describes. The SART examination itself, the redness and the erythema, and I know it's an uncomfortable thing to have to look at, but ladies and gentlemen, what does that show? What did Nurse Williams tell you? That when it is located in that area, that's consistent with the penetrative act, right? It's not diffuse, as much as Mr. Carlos attempts on cross-examination to suggest through his implication and innuendo. It's not because she lives on the streets. It's not because she's a dirty person. It's because it was penetration. That is separate, independent evidence of the act. Anally, the erythema, the redness. Again, there is no evidence whatsoever that Jane Doe, number 2, engaged in any consensual contact with her anal area with anyone at any point in time. And you heard the stipulation from the people in the defense that 3 days prior to this rape, she had consensual sexual intercourse with a partner. Had nothing to do with the rape, but the defense most likely will attempt to argue that it's going to show the erythema. But does that really make sense? The redness, the erythema, was most likely, more likely, attributed to the penetrative act with Mr. Winslow during the rape than one that would have happened 3 days prior. And there is no evidence to suggest that any consensual contact with the anal area occurred. So again, consistent, corroborative, forensic facts that show that Mr. Winslow penetrated her anally. So you heard the outcry witnesses and the deputies and the detectives and the prior statements that were made. And I bring that up because it's important, especially in this scenario. When someone is asked questions time and time again, it's difficult to be able to recall the specifics. When they're asked questions suggestively in cross-examination in court, it's difficult to understand what's being asked and to answer that honestly and accurately. Again, use your common sense. So what has Jane Doe number 2 ever been inconsistent about? Ask yourself, has she ever said that she wasn't raped in the way she described? Has the sequence of events changed in any way? Has she ever said that, well, actually, I was coming on to him, I was a little interested in him when he was threatening to kill me? Bless you. Now, ladies and gentlemen, she has been consistent time and time again to describe what happened. And the core facts are the same. And those are what matter, because those are the ones that prove the elements of the offense.
Just a moment. Juror number 9, are you doing okay?
Coughing away here.
Do you need to take a break? Need some more Kleenex at all, or?
I'm okay.
Are you sure? We can take a break if you want.
No, I'm okay.
Okay, all right. If you want to take a break, let us know. Do you want some water or anything?
I have water.
Okay, all right. All right, you can continue, Mr. Owens.
Thank you. Just allow them to take care of each other for a moment.
All right. Are we passing around cough drops or those? Mints. Okay. All right. And if anyone ever needs to take a break, just please raise your hand and let us know. Okay? All right, whenever you're ready, Mr. Owens.
Thank you. Thank you, ladies and gentlemen. As an aside, there have been a couple moments of levity in the course of this case, right? We're human beings. We're in a sterile environment. It's a difficult place to be. It can be a stressful place to be. And you're not even sitting in this chair. But it's hard, right? And you saw that. And we talked a lot during voir dire about what do we expect from a sex crimes victim? What do we expect to see? And I think we all agreed, and the reason why you're here and you can be fair and impartial is because you never know. Everyone reacts differently. You can be stoic and stone-faced like Jane Doe 1. You could be tearful and emotional like Jane Doe 4. You can be quiet and timid like Jane Doe 2. Or you can be feisty and mad like Jane Doe 5 or Jane Doe 3. Right? You never know. But what does that show you? It rings true. It's the truth. They all may react differently, but they all reacted honestly, based on who they are, from their own life experience, their own background, and their own experience of what he did to them. And while we might have moments of levity where we laugh because their investigator tries to run a red light, all that we have to do here now is treat it with the seriousness and attention that this case deserves. And you've all sworn to do that, and I'm certain that you will. On May 14th, the day that this was reported, the day that that SART nurse administered that SART exam and took down all of those prior consistent statements from Jane Doe number 2, there was a break in the case. She identified her rapist in a 6-pack lineup. And that makes sense, doesn't it? The eyewitness identification instruction tells you that a person who identifies another, the factors that you're allowed to consider are how many times does that person have an opportunity to see the person? What duration? How long? Jane Doe 2 was able to identify the defendant in a stranger rape case because she had seen him on prior occasions. Jane Doe 1 was not able to identify him in a 6-pack lineup because she had only seen him this one and only time in this traumatic, threatening event. Doesn't that make sense? Doesn't that also ring true? And at that point, the police then learned that Mr. Winslow was now a suspect in 2 separate forcible stranger rapes. And they began to build the case. So let's talk about consent. When we're talking about the elements of the offense, One of the elements that I have to prove is that this was non-consensual. How do I do that? The legal definition is that to consent, a woman must act freely and voluntarily and know the nature of the act, right? Freely and voluntarily. That they were willing, that they were open and allowed it to happen, right? That they wanted it to happen. That they affirmatively chose to engage in sex and anal penetration with a man they barely knew. That's what the defense would like you to find. And yet there's no evidence that's been presented of that whatsoever. The direct evidence from the victims themselves is that they did not consent. And there's been nothing presented to question that. It is not required that the woman physically resist or fight back in order to communicate the lack of consent. And as I talked to you about that earlier, why would the law ever require a woman who's being sexually assaulted to fight back? So we turn to Jane Doe 1. How did we start this case? DNA. Uncontested, indisputable, corroborated. Reference sample taken from the defendant, pants collected from Jane Doe 1, and it's a match in a sperm fraction, right? It's a stubborn thing. Can't get away from it. So then you got to come in here and say, well, then it must have been consensual, right? So we showed that this defendant committed that stranger rape, and now on trial, they're going to try to get you to buy consent. For Jane Doe 1 and 2 and 4, ladies and gentlemen, reject that. There's evidence that there was blood on the pants. There's evidence in the form of the forensic testing and the testimony from the DNA analyst. And then you also heard direct evidence from Jane Doe number 1's daughter, who says that the day after this happened, her mother calls her over looking for help. Help with the computer to be able to look up how to get tested for a sexually transmitted disease. And then a few days later, that she needs to report to the sheriff's department that she had been attacked. And the direct evidence is that she saw blood on the pants. Core facts. She's been attacked. She's concerned about her own health and safety. And she's reporting it to the police. Peripheral, outside, extraneous fact. Was it because she was already menstruating, or did he forcibly rape her that caused her to bleed? Ladies and gentlemen, she's a 58-year-old woman. Take it for what it is. She's said and testified she wasn't menstruating before, and then she may have been menstruating because of it, or as a result of it, or maybe she was spotting before. Does that really impact her credibility? Does that matter to you? She had been attacked. She was forcibly raped. Core facts that matter. And the DNA was in the form of a sperm fraction, so you can't get away from that. The sex act occurred, and then he left his own DNA behind. Again, not really in dispute. Where did this happen? On the backside of a shopping center on St. Patrick's Day, where there's not some large contingent of people coming and going from a Bonds back over here on the backside. Ladies and gentlemen, don't be confused by the obfuscation and the innuendo. You've seen the photographs. Anyone can get over that fence. But again, peripheral facts, extraneous. What does that matter? We know that it was him. We know that the sex act occurred. We know where it occurred. So why is she being cross-examined at length about whether it was a Jeep or if she saw a Jeep emblem? We have surveillance video from his own surveillance system that shows him leaving in his black H2 Hummer. Ladies and gentlemen, that's where it happened. Where else could it have happened? And coming back afterwards at 4:52 p.m. Jane Doe 1. Is she troubled? Does she have any form of mental illness? Is alcoholism enough to cause you to question everything she said? You know that she's private. You know that she's proud. And you know that she tried to hide the fact that she's been battling alcoholism for 30 years from you. As her daughter said, she lied about her alcoholism. It's for you to judge whether or not that matters to you when she's describing to you what he did, when he threatened to kill her and forced her to drive to that backside of the shopping center where he raped her. Ladies and gentlemen, when we talk about how a person reacts to that type of a crime, we talked about in jury selection, the shame, the blaming yourself. So someone who is private and has to be out here subject to public ridicule to testify about what happened to her, that's going to be hard. Someone who initially got into a car willingly with a stranger and then was raped afterwards is going to blame herself. When she sat before you, when you saw her, how many of you looked over at the defendant and thought, why? Did any of you think that that was a target of no strings attached sex from this defendant? Most certainly not. Is that reasonable? No. This wasn't about traditional sexual pleasure, an affair on the side with a woman he met on the street. This was vile, perverted, despicable sexual domination. That's what he does. That's why he targeted Jane Doe 1. That's why he brought Jane Doe 2 into this false sense of security and then took advantage of it. That's what he does. So we go to March 17th. She was hitchhiking on Santa Fe Drive. Yes, she's wrong on some of her facts. She thought it was a Jeep with a hard top. She described him as being half black, half Caucasian. If she had any idea that he was a football player or had money, wouldn't she come out and say, it was the football player who had money? No. She says that he was half black, half white, curly hair, muscular tattoos on his arms. Drove past San Diego High School and his attitude changed. He says, I'm going to fuck you, and if you say anything, I'm going to kill you. Again, consistent with what Jane Doe 2 says. Pull over right here. Don't take me in there. She begins to beg. At that moment, that's an important fact for you because it meets one of the elements that's required for you to find in the kidnapping. As soon as she communicates to him, pull over right here, let me out, don't take me in there, that is now a kidnapping. It is against her will. She does not have to fight, resist, or flee. The moment that she has now said, let me out right there, and he doesn't let her out, and he takes her to another place, that's a kidnapping. And when that other place is to the backside of the shopping center, that substantially increases the risk of harm to her, separate from just a rape that might happen where he first picked her up. So he says, I'm going to fuck you repeatedly. If you don't do whatever I want you to, I'm going to kill you right here. You heard from her. She might sound panicked when she testifies. She might sound strained when she testifies. But that comes from the panic and the fear that she was feeling in the moment, and now she has to come out and talk about it. I don't care, he's going to watch, I'm going to kill you. She was too afraid to scream for help, and she thought she was going to die. She doesn't know why she didn't run. She didn't know that was going to happen to her. She pleads with him. He says, I'll kill you. I'm going to fuck you right here. And he removes his spandex and exposes his penis. You heard from the testimony from the detectives and the crime scene specialists who collected all of the evidence at his residence during the search warrant on June 14th. He wears those clothes, right? We have corroboration that this defendant engaged in these acts. And he makes her perform oral sex. He pins her down on the front passenger seat and rapes her in the front seat of his car. She begins to bleed, and then he says, get out, get the fuck out. What else did you hear? You heard testimony that Jane Doe number 1 said the defendant told her, the man who raped her told her, I'm going to fuck you in the ass, when they were outside. What do we have happen with Jane Doe 2? He actually penetrates Raymond. Again, consistencies, interrelated evidence. Think about those things. And he drives off after he says, get the fuck out. And then she reports it a few days later. Now you heard from her daughter who described exactly how she responded, right? You have a witness who was the actual first outcry witness before she spoke to the police. And that makes sense, right? Her daughter, she's relying on her daughter to help her find a way to be able to get the help she needed. But because of the nature of their relationship, because of the type of person that she is, it didn't go any further than I was attacked. And I'm going to report it, don't worry about it. And then even so far as it wasn't me who was on the witness stand, right? All, again, consistent with what we know about her. Jane Doe number 1 was Kellen Winslow's perfect victim. The law applies equally to everyone. Jane Doe number 1 receives the same protections from a sexual predator like Kellen Winslow that Jane Doe number 2 does. And Jane Doe number 5 for that matter. It doesn't matter who. The person who put Jane Doe number 1 on that witness stand is Kellen Winslow, because he targeted her. He targeted her because she was older. Perhaps he thought she was homeless. Perhaps he thought nobody would believe her. That maybe he thought she won't even report it. But he chose her because she was who she was. He chose to rape a woman he met on the streets and a woman he knew to be homeless because he knew that he would be able to deny it. Now, rape as it relates to Jane Doe 1, we've already reviewed the elements. Again, it's sexual intercourse. The question is going to be consent. Secondarily, he's also charged, as it relates to Jane Doe 2, with an act of oral copulation by force or fear. Oral copulation is any contact separate from rape or sodomy, which requires the slightest penetration. It's any contact, no matter how slight, between the mouth of one person and the sexual organ or anus of another person. Penetration is not required, it's simply contact. But here, again, the act itself not likely to be disputed. So how do you use the other crimes that we've discussed now? We know that the acts have occurred. We have the issue of consent that you have to decide, and then we have to figure out, all right, is the defendant predisposed towards committing sex crimes because of what we found with Jane Doe 2? There's another way that you can use the other sex crimes. If you believe that I've proven that the defendant committed the rape or the sodomy of Jane Doe number 2, you can use the proof from that case to decide under Calcrim 375 if Mr. Winslow acted with the intent to commit rape or oral copulation during the kidnapping of Jane Doe 1. So if you find that Jane Doe number 2, what she described, happened, and you find him guilty of that, then you can use the fact that he committed those forcible sex acts against Jane Doe 2 to determine whether he intended to commit rape and oral copulation with Jane Doe 1 for the kidnapping charge. In evaluating the evidence, you have to consider the similarity or lack of similarity between the offenses and the acts. And how could they be more similar? Ladies and gentlemen, you have 2 separate victims separately reporting that he picked them up on the side of a road, he drove them to another location, and he forcibly attacked them. Separate women who don't know each other. No evidence whatsoever that there's some grand conspiracy among people in Encinitas to try to frame him, right? All the innuendo and implications that Mr. Carlos was trying to suggest with Jane Doe 1. Consider the similarity between the 2 crimes in determining whether or not he had the intent to commit the forcible sex acts against Jane Doe 1 when he kidnapped her. So let's talk about consent. Again, a woman must act freely and voluntarily and know the nature of the act. It's not required she physically resist. And as it relates to kidnapping, both aggravated and simple kidnapping that you've had defined for you, consent is an element. In order to consent, a person must act freely and voluntarily. Same element, but it may be withdrawn, right? There's evidence of consent initially to getting into the vehicle and then it being withdrawn. If at first a person agreed to go with Mr. Winslow, that consent ended if the person changed her mind and no longer freely and voluntarily agreed to go with or be moved by Mr. Winslow. The law tells you that. So that's a kidnapping. When she says, let me out right here, please don't go there, and he says no and continues to drive after telling her that he was going to kill her if she didn't have sex with him, that's a kidnapping. And when he makes it plain what he was planning to do, that's a kidnapping for the purpose of rape and oral copulation, which is an aggravated kidnapping. So he's guilty of both. The elements of kidnapping are listed here. They're lengthy. It shows that the defendant, or it requires that the defendant intended to commit rape or oral copulation, that acting with that intent to commit those forcible sex crimes, he either took, held, or detained a victim by using force, which I would submit is not here, but by instilling fear when he threatened to kill her if she didn't do what he said. That is here. Using that fear, the defendant moved the victim a substantial distance, and that'll be defined for you. That the victim was moved a distance beyond that merely incidental to the commission of the target crime. A target crime is the rape or the oral copulation. When the movement began, the defendant already intended to commit the rape or oral copulation, and that she did not consent to the movement, and that the defendant did not actually and reasonably believe she consented to the movement. Don't go there, let me out right here. Ladies and gentlemen, there's no argument that Mr. Winslow believed, reasonably or actually, that she was consenting to that movement. Substantial distance. It's more than slight or trivial. It could be pickup near Lake Drive on Santa Fe, and you could commit the crime at San Diego High School, right? Just more than slight or trivial. But what's interesting, what's required, is that it must have increased the risk of physical or psychological harm to the person beyond that necessarily present in the target crime, right? So being moved to the back of a shopping center, does that increase the risk of harm, either physically or psychologically to her, separate and apart from the rape and the oral copulation? When someone is isolated, alone, with their attacker, with their kidnapper, that increases the risk of harm to them. Consider all the circumstances related to the movement. Beyond distance merely incidental to the rape or oral copulation. That could have happened anywhere along the route, and yet he chose to take her to that place. He chose to take her to the backside of the shopping center. He chose to direct her off to the area near the side of the freeway. He chose to then seclude her within his vehicle where the acts occurred. All of that movement is in the course of a kidnapping. Consent, as I said, it may be withdrawn. Defendant is guilty of kidnapping if after the victim withdrew her consent, he committed kidnapping. So we go to the allegation. The allegation of kidnapping is separate from the actual substantive charge under count 1. So count 1, as charged, is that the defendant committed kidnapping for the purpose of rape and oral copulation. You also heard about a lesser included offense of count 1 called simple kidnapping, which basically means he didn't intend to commit rape or oral copulation. Okay? It has very similar elements. Also attached as an allegation in counts 2 and 3, 2 being the rape of Jane Doe 1 and 3 being the oral copulation of Jane Doe 1 by force or fear, is an allegation that those crimes occurred during the commission of aggravated kidnapping. So you have to consider all of the circumstances surrounding those forcible sex acts and ask yourself, was it a substantial distance? Was the risk of harm substantially increased? And if you find that he committed count 1, then the aggravated kidnapping allegation on counts 2 and 3, you will then find true to create the consistency. If you find him guilty of count 1, it's the same finding you need to make for the allegation on counts 2 and 3. The lesser included offense, as I said a moment ago, it only applies if you find that he didn't intend to forcibly rape and forcibly orally copulate her. It requires the same elements, the lack of consent, and the lack of actual or reasonable belief. So again, you consider all of the circumstances in deciding this allegation. Was it a substantial distance? Was the risk of harm substantially increased? If you find that the defendant committed count 1, then both the aggravated kidnapping allegation on counts 2 and 3 is true, and the lesser included offense allegation of simple kidnapping, which is separately charged on counts 2 and 3, is also true. Okay? If you find him guilty of count 1, then both kidnapping allegations on 2 and 3 are true. If all of the lesser included offense elements are met, but the defendant lacked the intent to commit the target crime, so if you find him not guilty of count 1, but guilty of the lesser included offense of simple kidnapping, then the allegation on counts 2 and 3 of simple kidnapping is true. All right? Let's talk about the law now. In addition to the substantive elements of each offense, the law also tells you how you should consider the evidence. One of the instructions that's given to you is Calcrim 302, evaluating conflicting evidence. If you determine there is a conflict in the evidence, you must decide what evidence to believe. If Jane Doe number 1 on cross-examination began to contradict herself, you have to decide what you want to believe. If she ended up being led down a road where she started to backtrack from what she had previously said, you have to decide whether or not that's true, or she was simply confused, or mistaken, or just tired, as Mr. Carlos continued questioning her. What is important in your evaluation of the evidence is whether the testimony or any other evidence presented convinces you of the truth of what someone said. You can use the evidence from Jane Doe 2 and what happened to her to determine if what Jane Doe 1 says happened to her is true. When the court gave you the instruction on witnesses, Calcrim 226, he told you, what was the witness's attitude about the case or about testifying as being one of the factors you can use to decide whether a witness is being honest and accurate and truthful, whether you find them to be credible. What was the attitude about the case? Everyone reacts differently. Everyone presents differently. How reasonable is the testimony when you consider all the other evidence in the case? Do you think Jane Doe 1 is making this up and lying? Especially when you consider the fact that Mr. Winslow committed these crimes against Jane Doe 2 and 4, 3 and 5? Did the witness admit to being untruthful? Yes. She did, about her alcoholism, about her arrest for public intoxication. She never lied, not once, about what the defendant did to her. So consider whether it's important or not. Did other evidence prove or disprove any fact about which the witness testified? Has there been any evidence presented that disproves what Jane Doe 1 says happened to her? Or Jane Doe 2 for that matter? The law also tells you, do not automatically reject testimony just because of inconsistencies or conflicts. The human brain is fallible. Memory can be fallible. But again, the core facts of what she testified to have remained the same, time and time again, regarding the attack and the forcible sex acts. You have to consider whether the differences are important or not, and people sometimes honestly forget things or make mistakes about what they remember, especially when they're being asked about testimony from last July or statements from last March. It's difficult to remember what was said. It's honestly difficult, as you can imagine. So we turn to Jane Doe 3. During the course of the investigation into the crimes against Jane Doe 1 and Jane Doe 2, they now have a suspect identified as of May 14th, 2018. The two separate investigations are now being coordinated to determine how they're going to approach the further investigation of this single suspect now.
And what happens? What happens? Jane Doe 3 on May 24th tells her husband, a man just exposed himself to me and they call the police. Jane Doe 3, not able to identify the defendant, provides a physical description that is consistent with Mr. Winslow. Again, 5'9" versus 6'4", the description is the same. Now, Jane Doe 3, what does she tell you? Similar to Jane Doe 1 and Jane Doe 2, this man comes up and introduces himself and gives her a false name. With Jane Doe 3, it's, hi, my name is David. Says he lives on Lake Drive. Again, ingratiating himself, appearing to be nonviolent, a good person. He comments on her flowers. She thinks nothing of it. She kind of waves it off, just a passerby who decides to enter into her front yard along her driveway. And he's gone. But a couple weeks later, this person who she thinks is David and lives on her street, living on Lake Drive, comes back. And initially she just says, oh, no, I'm just tending to my flowers. And she thinks, as you saw from the body-worn camera, as he's commenting on her flowers, that he wanted to see more. But what happens? As she said, he didn't want to see flowers. He exposes himself to her. And he smiles as he holds his erect penis a mere few feet away from her. And she reacted like anyone would. She's been violated. She's angry. She's offended. She cries out, no, 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 no. My husband, my husband. You saw the video of her reaction. That had just happened that day, that afternoon, right around 3:30 p.m. when a man in cycling clothes who parked his bike by her trash cans wearing a blue backpack with tattoos up and down his arms, muscular like a cyclist, as she described, decided to expose his erect penis to her. 11 days after his rape of Jane Doe 2. This is sick. This is vile. It's deviant. But it's also true. And it's what he does. Indecent exposure. It's a simple count, 2 elements. It just requires that the defendant willfully expose his genitals in the presence of another person who might be offended or annoyed by defendant's actions. Did Jane Doe 3 get offended by what he did? Not in dispute. When the defendant exposed himself, he acted lewdly by intending to direct public attention. He removed his erect penis from his biking shorts and held it in his hand and smiled at her. That shows intent to direct her attention to it. It's not required that another person actually see the exposed genitals, but here she most certainly did. Now, indecent exposure is one of the crimes that you can use under 1191B to decide whether or not the defendant has a propensity, a predisposition to commit other sexual crimes. Understandably, it is a different offense from rape or sodomy or oral copulation. But what happened? He staked her out. He introduced himself to her. He identified a new target who lived down the road from him. He then followed her into her yard as she walked away into the interior portion of her yard. And that's when he exposed himself. Get into the mind of a sexual predator. What was he planning to do, either then or when he came back? He knew where she lived. He knew what she did regularly. He had had multiple interactions with her. And you know now from the Strava application GPS data that he not only was there on May 24th, but he was there the day prior and had gone into her yard area, and I submit to you, looking for her, stalking her, because he planned to do what he did on May 24th, and perhaps more. So you've seen the locations that are at issue here. You know the defendant's residence on Lake Drive, and you know the location of Jane Doe number 3's residence. Just it was close to the intersection with Birmingham. You know that a blue backpack consistent with the one described by Jane Doe 3 was seized at Mr. Winslow's home. Is this an identification case? Because she said 5'9" when her husband interjected? No. It's been conclusively, beyond a reasonable doubt, proven that this defendant committed this indecent exposure against Jane Doe 3. But we didn't stop there. We also have photographs or still shots from a GoPro that was seized at his home, or a GoPro video that was downloaded from a laptop that was seized from his home, where it shows that he wears the exact type of clothing consistent with what was described by Jane Doe 3. It also shows that he was wearing the branding for Strava, the application that put him there that day. And it shows that he's wearing the shoes and a backpack that's consistent. Now, the Strava application. It shows that on 3:26 p.m. on Thursday, May 24th, this man who's sitting in court using that profile was there. That's been proven beyond a reasonable doubt. And circumstantially, the backpack, the clothing, and the location data shows that he committed this crime. The court instructed you on the difference between direct evidence and circumstantial evidence and how you can use each of those. This is a perfect example. You have direct evidence from Jane Doe 3 describing what this man did to her, and then you have the circumstantial evidence indisputably showing that it was this defendant. Just as strong, just as reliable as the other. Direct and circumstantial evidence can be used interchangeably. So then we move forward to June 7th of 2018. As you heard at trial, a resident called the police. There was a response to a dispatch report from the city of Encinitas. Deputy Sean Dwyer, the first witness who testified in this case, told you that he conducted a traffic stop of the defendant driving this vehicle, and this photograph had been provided to him by the resident. That during that traffic stop, he processed the defendant, and the defendant had a buccal swab taken in the photographs that I showed you at the outset today. June 7th. Why is that important? The first contact that the defendant has had with police results in the DNA reference sample being taken from his inside cheek. What does that cause him to do? After his photographs are taken, Roman, got to sell my car. What's up, bro? How have you been? Want to sell this Hummer. The same day that he's contacted by the police and his DNA is collected, he tries to get rid of the evidence. Essentially the crime scene where 2 rapes had occurred within months of this. The next day, on June 8th, the search warrant for the pole cam that was installed shows the very next day he gets the car detailed. Front seat, back seat, passenger side. You saw that they were actually spraying it down. On June 8th at 1:52 p.m., again, undeniable, indisputable, the day after his DNA gets collected by the police, he's trying to clean out his car. And yeah, they're going to stand up and argue, well, maybe he got his car detailed regularly. But ladies and gentlemen, think about the timing of that. Not only that, but on June 9th, he's taking the pictures of his car and sending them to Roman, his car broker. And then on June 11th, we show that Roman comes and buys it and takes off, right? And you can see that all happening within days of his DNA being collected. Why is that important? Why is it important that we then have a woman, Elizabeth Winters, who just lives in the San Carlos area of San Diego, say, all of a sudden a car showed up. I'm a mom and I've got young kids and we live by an elementary school, but then a car just showed up that kind of stood out. It was just ditched there, left there on the public street. I didn't recognize it, but it showed up the day before. Police showed up to her house asking questions about it. The defendant was trying to get rid of evidence. And what does the law tell you about that? under CalCrim 371, suppression of evidence can equal consciousness of guilt. And it's twofold. If the defendant tried to discourage someone from testifying against him, like he did with Jane Doe 1 and Jane Doe 2, he threatened to kill Jane Doe 2 if she told anybody, that conduct may show he was aware of his guilt. Again, that is separate and apart from the testimony of the witnesses themselves, and it shows his consciousness of guilt. It corroborates that he is guilty of these crimes. If he tried to hide evidence through the detail job and the selling of the car and the ditching of the car on a public street, that conduct may show that he was aware of his guilt. Is it really just a little suspicious? No. That's further circumstantial evidence that he committed these crimes.
All right, want to take a break right now?
Thank you, Your Honor.
All right, we've been going at it for an hour and a half. The court reporter's been pretty busy, so we're going to take our morning recess at this time. Please remember the admonition, don't discuss the case with anybody or form or express any opinion. We'll see you back here in 15 minutes. We're in recess.